Good morning. The 36th District Court is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no eating, sleeping, talking, gum chewing, or reading materials. Thank you.
All right, this is case number 24-158-632. This is Michigan Pain Management versus Suburban Mobility Authority for Regional Transportation. Your appearance for the plaintiff in that matter, please. Counsel on that matter. Do I have anyone from SMART on that matter yet? Thank you.
Right now.
All right, this is case number 24-165-680. This is LVMB Funding LLC versus Cynthia Mendez. The matter is before the court, set on for a pretrial conference also regarding the filing of a motion for summary disposition. Your appearance for LVMB Funding, please.
Judge, may I please court? I am Attorney Richard Rusin. I am the attorney of record for the plaintiff. I'm also the petitioner today in plaintiff's motion for summary judgment. My bar number is 35222.
All right, thank you, and good morning to you, Mr. Rusin. I'm looking now for Ms. Cynthia Mendez. If you're on this Zoom, please say something at this time.
Yes, I'm here.
All right,
I'm
thank
here.
you, Ms. Good morning, and good morning to you, ma'am.
Good morning.
So I notice here that this matter relates to the claim of a credit card agreement, and there has been the filing of a motion in that regard, seeking summary disposition. And I have the motion. I do not have a written response to the motion, ma'am. Did you file a written response to the motion?
When I had got it I think 2 years ago, I came downtown and I showed paperwork that I couldn't afford to pay this bill back, and I didn't hear anything. I tried to call the attorney a few times, but I never heard a response. And then I was given a subpoena.
All right, you never filed a written response to this motion that was filed. That was my essential question.
I didn't. I assume no.
Did receive just one moment. I received a package of stuff that you sent. This is something showing that you received Social Security as well as some utility bills. Is that correct, ma'am?
Yes.
All right, thank you. Mr. Rosen?
Yes, thank you, Judge. Judge, while the record was being made, I was reviewing my file. I see that I was retained as the lawyer for LVNB Funding back on July 19th of 2024. I can tell the court as an officer of the court that whenever anybody calls my office and speaks to my staff, that conversation is recorded with proper notification, of course. And notes are made. I don't see any time that defendant ever called my office. I don't have a copy of the answer to my motion for judgment. I did notice that this appears to be an assigned debt credit card, basically a one-time assignment from Synchrony Bank, which apparently is the bank that has Walmart as a brand name. And the credit card statements that I attached to my motion as supporting exhibits all show credit card use, credit card payment, then there is more credit card use, and then the last payment received by the bank servicing the Walmart credit card was, according to the bank records, November 25, 2018. The matter was charged off 6 months for non-payment under the applicable FDIC banking federal regulations, and then assigned to LVNB funding. I filed this motion for judgment based on defendant's answer. Judge, I will gently say as an officer of the court that because I don't show that defendant has ever spoken to my office, nor have I spoken to defendant, it may be prudent to go into a breakout room and speak to the defendant for a few minutes.
All right, that makes sense. It seems that the major thing that's being raised here is the defendant is saying that that she's unable to pay. And I mean, but it's worth talking.
Yeah.
If there are any parameters here. So, ma'am, I am going to give you a notification to go to a breakout room. And after you've done there, you come back in the courtroom. And Mr. Rusi will be.
From the last time we were here, I spoke to the lawyer in a room, and he said that he didn't want to accept the $50 a month that I offered to pay.
All right, do you want to go to the breakout room and talk
Well,
about
let's see if let's do that because I'm looking to see who's the attorney. But let's go in the breakout room.
Yeah.
All right.
Yeah, ma'am, click into the breakout room. You come back in the courtroom and I'll hear whatever you have to say on this. All right, this is case number 25-143-486. This is Marlon Braxton versus, let's see if that's right. Yeah, Marlon Braxton versus Portfolio Recovery Associates. The matter is set before the court for a hearing. Looks like this is the first hearing, a status conference in this matter. Your appearance in this matter, please.
My name is Mojir Ropik. I'm the agent for Portfolio Recovery Associates, formed here in Michigan.
Are you an attorney?
I am not.
All right, I'm looking for attorneys now. The portfolio is LLC. It has to be represented by an attorney. Is there an attorney involved?
Well, I'm the organizer of the corporation. I created the company in Michigan, but soon after.
I don't mean to be rude to you, but you think I care. I don't care. Because that company has to be represented by an attorney. That's the only issue I'm raising with you, okay? All right. Let me see if I have Marlon Braxton on this show. Marlon Braxton, if you're here. All right. So it looks like the plaintiff is not here, at least at this moment. It does look like the plaintiff is represented by an attorney, Mr. Taub, T-A-U-B. I'll come back to this and call it again in a few moments to see where things are. In the worst case scenario, the matter looks like it will be adjourned, and then you'll need to come back with a lawyer because you can't speak for the LLC. So I'll come back to that in just a few moments. Give it a moment to see if the other side comes in. All right, this is case number 24-165-612. This is Richard Baker versus Member Select Insurance Company. The matter is before the court, settling for a pretrial conference on today's date. Your appearance for Member Select, well, it looks like both sides are represented by counsel. Any counsel on this matter, your appearance, please.
My apologies, Your Honor. So Arable, on behalf of plaintiff, I am in another hearing. I'm trying to do both at the same time.
Got you, ma'am. All right, Wilson. For a moment. Do I have Member Select on this Zoom?
Yes, good morning, Judge Nikisa Monavari on behalf of the defendant.
All right, thank you. Ms. Arable, are you able to go forward or do you need to deal with the other matter?
That's all right. I can go forward.
Go ahead and put your P number on, Ms. Arable.
What is it? I'm sorry?
Your P number on the record, if you will.
86220, Your Honor.
All right. My last notation on this is relative to a deposition that was going to be taken. Looks like that's set for today's date. Somebody update me and tell me where things are.
Your Honor, the deposition is actually scheduled for tomorrow, April 29th. It's the deposition of the plaintiff and the plaintiff's care service care provider. I did see an email this morning from my office to Ms. Arabo's office asking to confirm. However, I have not yet seen a response.
All right, so I'm wondering, well, it seems to be that you're not going to get much traction on this until after that deposition tomorrow. If that sounds about right, Ms. Arabo?
Yes, Your Honor.
What if I set it over for 30 days and give the parties an opportunity to, to try to figure this out? And I'll look towards setting it on for either a final pretrial conference or a trial date on the next action date. We'll take a look at it 30 days. And so I'm going to set that new date for the, in fact, for the 28th of May, May 28th at 9:30 a.m. The matter is adjourned for good cause. And it's set over for the 28th of May at 9:30 a.m.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Is that good? That'll work.
All right, we're on the record regarding case number 24166896. This is Citibank versus Rowena Gulson. The matter is before the court set on for a status conference. This is the first hearing regarding this matter. Your appearance for the plaintiff, Citibank, please.
Good morning, Your Honor. It's Craig Fay, P81401 on behalf of plaintiff.
Great, thank you, counsel. Good morning to you, sir. Do I have Rowena Gulson, please? All right. Good morning, ma'am.
Speaking.
All right. Good
How
morning.
you doing?
All
Good
right.
morning.
Thank you. All right. Counsel, I know it's your first hearing. Have the parties had an opportunity to talk about this? Tell me what's going on, please.
So I think this might be the second one. The first one, I believe, on April 1st may have been adjourned. I believe Ms. Golson indicated that she was going to try to hire an attorney to appear. So I'm not sure if that's taken place.
No, I am representing.
Go ahead, ma'am. What did you say?
I'm represented by consumer legal debt.
All right. And so why aren't they here today, ma'am?
If you're going to just to interject, it looks like we do have them on file. They're a settlement company, not necessarily have an attorney appear. So if that's who Ms. Golson is indicating is representing her, we have been in contact with them, trying to negotiate them.
All right. So what I'll do then is I'll set up a scheduling order in this matter and allow that process to move forward, and hopefully the parties can reach an agreement in that regard. So what's going to happen is that I'm going to set a return date on this matter. That return date is going to be June the 30th. It's going to be 6/3/25, June 30th, 2025 at 9:30. I'm going to issue a scheduling order. Now you're going to get that in the mail from me in the next couple of days. That scheduling order will have the date and everything contained within the document. And then I will review this matter on 6/30/25 at 9:30. I do wish both sides well, and I'll see you on that date.
Perfect. Thank you, Your Honor.
All right, good day to both sides.
Okay, thank you.
Yes.
Bye-bye.
All right, now. Mr. Fay, did you have another matter, sir?
I do one more. It's a LVNV versus Jones.
All right. This is case number 24170246. This is LVNV Funding LLC versus LaShawn Jones. The matter is before the court, set on for a pretrial conference date. The court did previously issue a scheduled order regarding this matter. Appearance at this time, counsel.
Okay, good morning, Your Honor. It's Craig Fay, P81401 on behalf of plaintiff.
Thank you, counsel. And again, good morning. I'm looking now for LaShawn Jones. If you're on the Zoom, please say something at this time.
Good morning, Your Honor. I'm here.
All right. Thank you, Ms. Jones. And good morning to you. All right. Mr. Fay, update me on where things are regarding this matter, sir.
Sure. So we did discuss in the breakout room, and we did come to a resolution by way of conditional dismissal. So I'm not sure if the court would allow, we can place the terms on the record and then either submit it under the 7-day rule. Otherwise, I told Ms. Jones that we can have the conditional dismissal mailed out for her signature.
All right, you can go ahead with the terms, and I'm noting my file regarding the fact that there's a conditional dismissal agreement. Go ahead, sir.
Perfect. So the conditional dismissal, Ms. Jones is going to settle the amount or the account for $425. That's going to be paid over 2 months. The first payment equal monthly payments. The first payment due May 28th, and then the second payment due June 28th of 2025.
All right, and you've heard the terms as set forth on this record, ma'am.
Yes.
The case was totally dismissed, contingent upon the payment of $425 in equal increments. The first one being due on the 28th of May, and the final payment being due on June 28th. Is that, in fact, your agreement regarding this matter, ma'am?
Yes, Your Honor.
All right. I will then note that the case has been resolved, and I will anticipate the order that's congruent with the same. And I wish both parties well. Good day to you.
Sure. And Your
Thank you.
can I submit that under the 7-day rule, or do you need Ms. Jones?
If Ms. Jones, those terms is set forth on this record, do you have any problem with counsel placing your name on that document by consent based upon what was agreed to on the record?
No, Your Honor. I consent. No problem at all.
All right. So submit it in that way, counsel, and there is a as you may, and we'll go forward accordingly. I'll sign it upon its present.
Perfect. Thank you, Your Honor.
Thank you, Your Honor.
Good day to both sides.
You too.
Thank you.
Goodbye.
And welcome back, Mr. Rosen. I'm coming to your matter. I think I am.
Well, it is Monday. I understand.
Yeah. It's Monday, and I just got back from a wonderful cruise with the wife and children. What was that? What was that case?
My idea of a cruise is just going up Woodward Avenue in August, but I think you would have had a better time.
Well, it was a great time had by all, and of course the children, the 11 and 14-year-old.
Yeah. You didn't take that other judge from Harper Woods with you, did you?
No, she wasn't able to go there this time.
Oh dear.
She just got back from Vietnam with her son about 3 weeks
ago.
Right?
Wow, now that's actually a place I always wanted to go to, but I didn't want to go to there in 1974 when they were doing the draft. But
for sure. All right, remind me which file.
All right, yes, very simply, Judge. This is file 24-165-680, which is entitled LVNB Funding versus Cynthia Mendez.
Yeah. Okay, I've got it. All right, and welcome back. Let me see if I can get Miss Mendez out of the breakout. I believe that's where she remains. Just one moment, sir. All right, welcome back, Ms. Mendez, and welcome back, as I indicated, Mr. Ruza. All right, Mr. Rusin, update me. Where are things at this point, sir?
Yeah, Judge, thank you. For the record, Richard Ruston, my bar number 35222. I'm the attorney of record with the plaintiff. Judge, while we, Mr. Mendez and I were in the breakout room with the case being in recess, the parties have agreed to enter into a consent judgment in the amount of the complaint. The complaint was filed in the sum of $4,290.60. That's 4290.60. I explained to Ms. Mendez that statutorily, there is some cost in filing and moving these civil matters along, which are taxable costs. I explained that to Ms. Mendez. And I explained that there is a $75 statutory filing fee for the summons, also a $51.10 summons service fee for serving that summons on Ms. Mendez. And there was a $20 motion fee that was concurrent with filing the plaintiff's motion for judgment today. The total taxable cost, Your Honor, are $146.10. That's 146.10. I also noted that there is a $20 statutory attorney fee concurrent with the filing of these sort of motions for summary judgment. That's an attorney fee. And the total judgment will enter in the amount of $4,456.70. That's 4456.70. The parties have further agreed, Your Honor, that there will be, concurrent with the entry of the consent judgment, a $50 monthly installment payment order beginning June 10, 2025. And as I explained to Ms. Mendez while the case was in the breakout room and recess, I now ask on the record for Ms. Mendez's permission to sign her name to the proposed consent judgment so that in turn, Your Honor, I can hand file that order with the clerk's office of the court after 3 p.m. today. With that, I rest.
Thank you. Ms. Mendez, I've looked at these terms coming to a total amount of $4,456.70 with an agreement commencing in June the 10th, $50 per month paid monthly during the pendency of this matter. Is that in fact the agreement that you've been able to reach in this matter?
Yes, that's all I can afford.
All right, ma'am. All right, and so Mr. Rosen is going to submit that document with your name on it based upon the record that's been presented here and your agreement on the same. I'll go ahead and sign that. And again, the payments will be $50 a month starting on June 10th. Okay
Yes.
with you, ma'am?
Yes.
All right, thank you very much, ma'am. We'll get that order out to you as quickly as we can. And you already know that June the 10th is when the paper start. I wish you well. Thank you. Thanks to both of you.
All right.
Bye.
Thank you, Judge. I rest.
Ms. Crapo, which matter do you have, ma'am?
Morning, Judge. I'm here on the Michigan Pain Management case. And my last name is pronounced Crapo. Sorry to correct, but.
No, you need to correct me if I got it wrong, you know. So much for us guys that have last names like Coleman. Thank you, Counsel. And then anytime if I say it wrong, make sure you let me know so I can get it right. All right. So that's pain. Is that pain management? Which one is it?
Pain management. Ending in 632.
All right. So we're on the record regarding 24158632 pain management versus Smart. All right. Your appearance, respectively.
Good morning, Your Honor. Alicia Rubin, P78962, appearing on behalf of plaintiffs.
All right. Thank you, Ms. Rubin, and good morning to you. And then your appearance at this time, Counsel.
Good morning, Your Honor. May it please the Honorable Court, Caitlin Crapo, P86272, on behalf of defendant in this matter from Vanderveer Garcia. Thank you.
All right. Thank you, Ms. Crapo. And I have some notes here. It seems to me that the parties, there was a motion to, that was withdrawn. There was some discovery that remained outstanding, adjourned matter until today's date to try to clear that issue up. Somebody talk to me.
Yes, Your Honor. You did, they have requested depositions, sent out notices. We're working on some dates for them. We have also discussed potential resolution for the case. I think we just need a little bit more time. There's not a ton at issue. So we're trying to figure out if we can do it without the depositions, basically.
Sounds
So
about
maybe
right.
45 days?
Yes, Your Honor, that's a complete recitation of our discussions.
All right, so I will go ahead and set it out about 45 days, and we'll have it come back as simply as an adjourned pretrial date. So next action date in this matter going to be the 17th of June. It's going to be 6/17, 25, and that's going to be 9:45 a.m. 6/17, 25, 9:45 a.m. There will be another notice generated, but please take the note of this time. All right, and I will see you at that time. Good day to both of you.
Thank you, Judge.
Thank you so much.
Thank you.
Have a good day.
Happy Monday.
All right, on the let me see what that. All right, Madam Counsel, what case are you on?
Morning, Your Honor. I'm here on the DME Dudes versus Smart matter. That is.
I got you. I'll be right with you.
Thank you.
All right, thank you. All right, back to 25143486, Marlon Braxton versus Portfolio Recovery Associates LLC. All right, it appears that the plaintiff's counsel is not present. It also appears that no counsel is present for the LLC. I'm going to set this over and give it a new date, and I will review the matter at that time. The plaintiff will be notified as well. If the plaintiff doesn't appear at that time, it doesn't matter who appears. Otherwise, the case will be dismissed. But you do need, sir, you do need to have an attorney involved in this matter because you can't speak for the LLC in the context of a general civil matter. If it was in small claims court, you could do that, but you can't do it. This is not small claims. This is the general civil division. All right. So the next action date in this matter is going to be the 21st of May, 5/21. 25, and that's going to be at 9:30. I'm going to send out a notice regarding this matter to the parties that are involved, and I've already said what the parameters are regarding this matter. That will be 5/21/25 at 9:30 a.m. Come back into the same Zoom. All right, good day to you, sir.
Thank you.
All right, this is case number 24169884. This is DME Dudes LLC versus Smart. The matter is before the court. looks like I have you set on for a pretrial. Counsel, your appearance at this time.
Good morning, Your Honor. Yes, Veronica Prang, appearing on behalf of Defendant Smart.
All right, thank you, counsel. I don't see the plaintiff, but I received a, well, I'm looking now, I see that I signed an order denying Smart's motion to dismiss. For failure to pay the sign transfer fee. And I set this up for a pretrial conference on today's date.
That's correct, Your Honor. I actually have a, if you would so allow, I'd actually like to ask for a couple clarifications from the court. So two things. I don't see plaintiff's counsel either, and they're normally here. I don't know if maybe you want me to give them a call. What I'm going to ask you is really just more administrative with the court as opposed to any substantive. And then maybe I can give, either way, I can give counsel a call if you prefer before we get started. Or like I said, I just have a few administrative questions for the court before substance of the case.
I see, I think I see what the problem is here. This is set to Judge Sabri, but it's my my Zoom number.
Yeah, Your Honor, can I give you like a background on this? So this case was originally before Judge Robinson, and he retired early. So we appeared for we never got notice of a pretrial that we appeared for in December, but my office happened to see it on the Register of Actions. So we appeared and we waited for some time, and then because Judge Robinson hadn't appeared, you did appear, and you heard you had us have a pretrial and set it with your scheduling order. And then after that, I think the case was supposed to be moved to Judge Sabri, but because you had taken the pretrial and you had issued a scheduling order, you indicated that you were going to handle the case. There's been some confusion administratively with I think, your chambers and Judge Sabri's chambers and the clerk's office. We've actually tried to get clarification a number of times, and it's not, I think there's some confusion because at one point we did have Judge Sabri's name on it. We've had your name on it. And I think the orders, and we have a motion for reconsideration that we filed over a month ago, and we're not sure which judge has seen that either. So a couple of things. With that all said, we're not sure. Last time we had a pretrial, because you were the scheduling judge and you were the scheduler, despite the fact that it said that we were supposed to appear in front of Judge Sabri, we tried to, they said, no, you had the case. And then we appeared in front of you again. And you said that you were going to handle the case. So it does say on the notice that she's the handling judge and her information, but I appeared in front of you today because the last time we tried to, they indicated it's your case. But I will say the Register of Actions still says that Judge Sabri is the judge. So there's a few things going on here. The party submitted a motion, or excuse me, an order for compelling plaintiff to supplement discovery. We're not sure where that is. I know that we've mailed it in. We don't know if it's with you or if it's with Judge Sabri, and it's not clear who's supposed to be signing it. Still, just because, like I said, you indicated that you're handling this case. We have appeared in front of you exclusively, and despite what the Register of Action says. In addition, because there was some confusion as to which judge was handling this case, you heard our motion to dismiss for failure to pay transfer fee, and we submitted the order. We didn't get it back, and it hadn't been signed within 21 days. So in order to make sure we didn't miss our deadline, we filed it before you had signed the order denying the motion. So we submitted our motion before technically the order was entered, just to, preserve our client's interests. I don't know, Your Honor, if you have that motion for reconsideration or if it's still in limbo in front of Judge Sabri. So generally, I think there's just confusion across the board, and I do apologize, Your Honor. I know it's 10 a.m. on a Monday, probably not all the things you want to be hearing. So I guess I'll say secondarily too, I don't know if counsel's in front of Judge Sabri right now, but again, last time we did try to appear in front of Judge Sabri, and they specifically said, no, you need to go in front of Judge Coleman. So I know, again, I apologize. I know this is a lot. I just want to make sure you have all the information.
Got it. I sat in for, because I preside over the civil division, so I sat in when Judge Robinson took his leave.
Right.
And as I sat here and I came across this particular matter, I indicated that I would keep the matter with me. And I thought that that would be expeditious in the sense that I knew that Judge Sabri was coming on, but I also knew that she would need some time to catch up with some stuff. So in that transition, I indicated that I would keep this case. I had no idea it caused the kind of confusion, because I think what happened is that while I said I would keep the case, it was never assigned to me. And I could administratively make that decision, but it was never formally assigned to me. So that's why you've been caught kind of in that gap a little bit. I did issue the order regarding denying the motion to dismiss regarding the fees. That order was signed on the 28th of March. I think that that's pretty much the only significant order that I've signed in this matter. And maybe at this point, it's in the best interest of the management of this file for me to simply bow out and set it up in front of Judge Sabri so that the parties can have some level of congruence in going forward on this matter. Counsel?
I'll leave that within your discretion, Your Honor. Whatever works for the court. Like I said, I completely understand. I know that this obviously a lot of administrative stuff going on with Judge Robinson retiring. So yes, whatever you believe is in the best interest of the parties. Like I said, we'll leave it within your discretion. I guess the only thing I will say is because you did hear the motion to dismiss, we'd ask, I also don't want to overstep. I think you were the one who has to review the motion for reconsideration because it was your determination. Otherwise.
Yeah, it's going to get more complicated.
Right,
Yeah.
right. So I know there's a lot of moving parts, and I know there's a bunch of confusion, I think, across the board, but whatever you think is easier for the court, we will leave that within your discretion.
All right, thank you. Thank you, Counsel. So I'm looking to see if I actually have the motion for reconsideration. Just one moment, just looking to see if that's.
Yeah, and if it's easier for you, Your Honor, if you haven't received it, I might have your clerk's email actually. Would you mind your clerk's first name?
Latifah Hunter.
I have spoken to Latifah. She's fantastic. Her last name's Hunter, right?
Yes.
Okay. If you would like, we can forward a copy of the motion. Obviously, we would CC counsel as well, but obviously, like I said, let me know and we can do whatever is easier for the court.
Got it. All right. So I do not see where that motion for reconsideration has populated to the file. So it'd be good to resend that. And I'm sure that you've already sent a copy to the other side. I'm going to go ahead and set a date for hearing on that motion, and then we'll send out a notice, and then of course you'll spread the word that it'll be in front of me for that motion for reconsideration. So the date on that motion for reconsideration is going to be the 22nd of May, 5/22.
Okay. At 10?
9:45.
9:45. Okay. And then, like I said, I do have a couple of subs. I'd like to make some substantive requests as far as continuing discovery on this matter, Your Honor, but I don't know if you'd prefer I try and contact plaintiff's counsel. I'm surprised they're not here. They typically are.
Maybe the confusion of the courtroom. So I will continue discovery through 5/22, and I'll revisit the issue at that time. So discovery remains open through 5/22, and then you could raise any other issues that might need to be raised at that time.
Okay. Thank you, Your Honor. Thank you for, as I said, listening to my long spiel about all the things that are going on in this. I appreciate your time.
That's okay. I appreciate it. Thank you.
Thank
Good day
you.
to you.
We will forward that a copy of the motion this morning, and like I said, we'll CC Plano's council. Yes, they have received it already. If you need anything else, please let us know. Otherwise, have a nice day and a nice rest of your week, Your Honor. We look forward to seeing you in May.
All right. All right. Good day to you.